I'm going to go into last will and testament. Really, it's what people think about when they think about estate planning. It's not the only document. It's the document that will devise and bequeath your assets, any probate assets that you have when you pass away. There are things that can be done during the process of planning that could reduce the amount that is subject to probate, but generally speaking, a will is going to devise any property that you have, whether that property is a specific bequest, something like a diamond ring, that you'd like to leave to a specific individual. You can obviously lay out those tangible property items in a last will and testament and give them to this person, and if this person predeceases you, then to this person. And your personal representative, or executor, as some people come to have known it, is going to be responsible for making those distributions that you've thought out with your attorney or not ahead of time, before you've died and while you're competent. And that's really a point I want to drive home, is it's not just about being alive doing the last will and testament. We also don't know how long someone might live when they're not legally competent to make a legal document that's going to allow them to make changes in distributions of property upon their passing. Sadly, there are sometimes individuals I'll deal with who are questionably competent. We have to get second opinions on whether or not that person should be creating a legal document that's changing something. As you might imagine, as someone's in their dying days, people kind of rush in, come out of the woodwork, and try to make changes. And I'm not saying that sometimes those changes aren't really what the individual wants, but if there's a legal question of competency, that creates a real problem for judges in determining whether or not someone was under undue influence. And then it costs a lot of money paying lawyers for both sides, fighting over the value of whatever it is that's been distributed. Sometimes we can be talking about something that's just purely sentimental, like family photos, or maybe a ring that has some value but not a lot. Or we can be talking about something where someone's transferring hundreds of thousands of dollars worth of stock out of one person's name into another person's name mere days before their passing. So as you might imagine, it's better to think about these things now while you're capable of making your own decisions. And it's not to say you won't change your mind. You're entitled to change your mind. Everyone is. And a last will and testament can be changed even after you've executed it, but you have to be legally competent to make those changes. Now, I spoke about probate property. Probate property is going to be anything that doesn't have a designated beneficiary. A designated beneficiary would be something like if you have a life insurance policy and you've named someone on that policy, or someone's maybe contingent beneficiaries as well. Those kinds of assets are going to pass by operation of law outside of your last will and testament. So it wouldn't matter if I have a New York life insurance policy worth $100,000 and I've named my spouse as my primary beneficiary and my two kids as the contingent beneficiaries. If any of those individuals are alive upon my passing, that asset, that $100,000, is not going to go through my last will and testament. It's going to be devised by the life insurance policy, the contract I've created with that company. So all that asset's going to go along to those people. So a lot of the common misconceptions when someone will come into my office, they think that money is going to be part of their will, and they want to talk about that money and how they're going to distribute it all. That's not how that money gets passed along. However, if that is how you want it to be passed along, we can designate your estate or a trustee, if you're creating some kind of a trust for handling that money, to be distributed to the trustee, who will then distribute that money to your intended beneficiaries in the way that you've decided, rather than maybe just an outright distribution. For example, let's say you have a grandchild, and you want your grandchild to benefit from that $100,000 policy, but you know they're not capable or responsible enough at that age, who is, of handling that money in a responsible way, the way you want them to. So you might designate someone that you do trust, maybe their aunt or uncle, or their mother or father, to handle that money for them. And there'll be certain designated terms in the trust or the will document that will tell how they want that property to be distributed over time and in what ways. Very common for me to be dealing with young families with little kids like I have. And we will devise a plan. Nobody knows what their kids are going to be like 15, 20 years from now, but they'll say, they want certain people that they trust to be guardians of those children. Sometimes they'll designate trustees as well, who will be different from the guardians. Someone who will handle the money for the child, someone who will handle the care and legal decision making for the child, And that way they can make distributions maybe at 18, at 25, at 30, so that the money lasts a little bit longer, so that it's maybe used in the way that you want it to be used. Now, going on a little further into the last will and testament, without getting into too many details about it, it's important that a last will and testament has the correct formalities. I have seen on more than one occasion individuals who've come into my office, and on one of these occasions the individual had already deceased and his daughters had come in. He had a will that it looked like he had intended to execute, but he didn't have the proper number of witnesses. He had signed it. He had one of his neighbors sign it, but he had another blank space that no one ever signed. So in Maryland, to have a validly executed last will and testament, you have to sign it, and you have to have 2 witnesses, and this person only had 1. So we had to judicially probate a will. The will basically was invalid because it hadn't been validly executed. Luckily for this particular individual and his estate, the way the state law coincided with what his will desires were wasn't terribly different. So he kind of lucked out in that regard of an accident that took place, but it could have been dramatically different. Had he, let's say, intended for someone other than his 2 daughters to split his estate and he was divorced, that money could have been given to, maybe he would have been estranged from one of his daughters. Maybe he had no relationship with them and he didn't want them to receive anything. Well, had he done this will, drawn it up the way he drew it up, and then not had it witnessed appropriately or had it executed appropriately, it could have all been for naught, and he would have wound up giving half of his estate to a daughter he hadn't spoken to in 15 years. That isn't what happened here. But as an example, I want you to know, it's so important to not just print off documents or use something that somebody else has created and use it as your own, because that is, in my opinion, what is worse than not having the document at all is having something that you think is valid and it's not. And that really is a false sense of security, and you won't even realize you don't have what you need. At least if you don't have the documents, you know you need to get them at some point. If you have something that you think is right and it's not, you could be going down the wrong path for a very long time, and then when it's too late, someone's left holding the bag, and potentially there could be big fights brewing. So I try to avoid all of that by just going through the professional channels. Usually can do these things at a very reasonable price, in my opinion, and feel very good about them when you're done.